We are going to be reading for you guys line by line the analysis for the City of Wayne open burn policy, their former open burn policy, the one that they relied upon for many years to violate your 4th and 14th Amendment rights. So this addendum is called Vagueness of the City of Wayne Open Burn Policy. My name is DeVincent McFarland Sr., aka Versace Vince, and I am the host of Wayne County Audit and Fucking Around TV, where we fuck around so you can find out. And my table of authorities for this, Gray Ned versus City of Rockford, 408 U.S. 104, 1972. Papa Christou versus City of Jacksonville, 405 U.S. 156, 1972. Colender versus Lawson, 461 U.S. 352, 1983. Giacio versus Pennsylvania, GIACCIO versus Pennsylvania, 382 U.S. 399, 1966. Coates versus City of Cincinnati, Coates, COATES versus City of Cincinnati, 402 U.S. 611, 1971. City of Chicago versus, Morales, 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 527 U.S. 41, 1999. And finally, Mapp versus Ohio, 367 U.S. 643, 1961. I would like to say that Papa Christou is one of the common themes you'll see. PAPACHRISTOU, Papa Christou versus City of Jacksonville. So here's the analysis. The policy that I'm about to read off to you is verbatim. This was what the City of Wayne open burn policy is, and or was rather. And this is just an analysis of it. So, first of all, when you go on the City of Wayne website, the PDF file is called Open Burn Policy. So just keep that in mind. However, the title is called Policy for Controlled Fires in the City of Wayne. The following documents address the subject of open burning. These documents include specific language from the Wayne County Air Quality Division, City of Wayne codified ordinances, NFPA 1, and the AIA Fire Prevention Code. The document labels itself a policy for controlled fires, yet immediately pivots to open burning, terms the city never defines in any codified ordinance. This bait and switch creates uncertainty from the first sentence about what conduct is regulated. A resident reading this cannot tell whether the city is prohibiting open burning, permitting controlled fires, or regulating both under different standards that are never coherently explained. Due process requires fair notice and workable standards. A moving target is constitutionally inadequate. See Graned, GRANED versus City of Rockford, 408 U.S. 104, 1972. These documents include specific language from the Wayne County Air Quality Division, City of Wayne Codified Ordinance, NFPA 1, and the AIA Fire Prevention Code. This sentence concedes the city has compiled a cut and paste memorandum from disparate sources, rather than enacting a clear ordinance. Some cited sources do not prohibit open burning, Wayne County. Some are irrelevant, Christmas tree sales, junkyards, parks, wrecking sites. Others are national standards never adopted in Wayne, NFPA and AIA. And still others are phantom sections that don't even exist. Citizens cannot be subjected to criminal enforcement under a collage of materials that change with the enforcer's preference. Such unchanneled discretion is the core evil the vagueness doctrine forbids. See Papachristou, Papachristou versus Jacksonville, 405 U.S. 156, 1972, and Kolender versus Lawson, Kolender versus Lawson, Lawson, 461 U.S. 352, 1983. Let's continue. Wayne County air quality. Wayne County's 1998 ordinance does not expressly prohibit open burning. The policy admits the county does not ban open burning. This undercuts any implication that a larger governmental body has imposed a clear prohibition. And then we get into their ordinances, right? Well, they're not ordinances. I'll explain that in a minute. Ordinance 812.06, the burning of Christmas trees on a lot for the sale of the trees is prohibited. Commercial Christmas tree lots only, irrelevant to residential yards. So we can just skip that ordinance. Next ordinance, 832.17, the burning of junk in any product resulting from the dismantling of junk or automobiles is prohibited. Junkyards and auto dismantling, not backyard fire pits. So doesn't apply. Ordinance number 1062.13, no person shall light or make use of a fire in the park system, except in such portions thereof as may be designated by the Department of Parks and Recreation. Applies to parks, not private curtilage. So doesn't apply here. Here's the next one. Ordinance number 1060.26. No person shall burn solid waste any place in the city other than in incinerators approved by the fire department. Well, that's solid waste regulation, not an open burn ordinance. It has nothing to do with open burning. So, again, irrelevant. Here's the next ordinance. 1060.27, no person shall burn any substance upon any street or alley of the city which has been surfaced with concrete or asphalt coating. Street alleys only, not private yards, so it doesn't apply to my situation here. Next ordinance, 1460.07, the burning of material or debris on premises whereon wrecking operations are taking place or have taken place is prohibited. Well, if you read that, you'll notice this is applying to wrecking demolition sites only. Another, it's irrelevant again, but I would like to add the way that that's worded, or have taken place. So basically what they're saying is any lot, essentially, where something has been built or constructed, it's prohibited, right? Because read it again. 1460.07. The burning of material or debris on premises whereon wrecking operations are taking place or have taken place is prohibited. So if you read that, then it basically says you can't have open burning, which contradicts the rest of it, right? So it's worded like, it's almost worded as people in Wayne tried to sound smart, and really they just sound like, I'm just going to say it, retards. They just sound like retards, right? Like, this is the best that they could come up with, right? This is what you paid money for. This is what the council and the city attorney at the time and the mayor at the time, they looked at this and said, oh yeah. Well, no, they didn't actually. That's the thing. The fire marshal created this, right? The fire marshal of Wayne, Jeremy Schneider, right, I think he's illiterate. I really do. Because he wrote this and he signed his name to it and he's proud of it, and he doubled down and enforced it and said, oh no, this is the law, right? So, demolition sites don't apply here, irrelevant. Well, here we go. Here's the two bangers here. Here's what you guys have been waiting for. Ordinance 1278. This ordinance deals with pollution and has technical requirements that we are not capable of determining for air quality. Okay, sounds like it invalidates itself. Let's continue. Subordinates 1278.07 addresses odors that may be offensive to neighbors. You see that word may be offensive, right? It's arbitrary, it's vague, it's non-descriptive. Sections 1278 and 1278.07 are phantom. These provisions do not exist in the city's codified ordinances. They've been repealed. We don't know when they've been repealed, but they've been repealed for years before May 9th of 2025 or March 28th of 2024 for that matter. The policy nonetheless invokes them and astonishingly admits the city is not capable of determining the technical requirements it claims to enforce. This is a confession of legal indeterminacy and administrative incapacity. Residents are told to obey standards that both, one, do not exist in the code, and two, cannot be applied by officials. Vague, undefined, or non-existent standards violate due process because they fail to give fair notice and invite arbitrary enforcement. Isn't that interesting? See GIACCIO, GIACCIO versus Pennsylvania, 382 U.S. 399, 1966. City of Chicago versus Morales, MORALES, 527 U.S. 41, 1999. So your non-codified open burn policy is citing phantom ordinances, 1278, 1278.07, which do not exist in the city charter. They've been repealed a number of years ago. I wonder why. Maybe because somebody looked at them and said, these are retarded. These are retarded. So let's continue. NFPA 1 edition 2000. Open fires shall be located not less than 50 feet from any structure. Open fires and cooking fires shall be constantly attended by a competent person until extinguished. Competent person. A garden hose or other water supply shall be readily available for use. We got those. Don't worry. The fire department may prohibit all outdoor fires during a dry spell. Okay. These national standards may be sensible as guidance, but they are not law in Wayne unless duly adopted by ordinance. Borrowing standards by reference inside a policy PDF does not supply the clarity or democratic legitimacy the Constitution requires for criminal enforcement. Residents are entitled to rely on the published city code, not on unadopted manuals. The mix and match approach also creates contradictions elsewhere in the policy, i.e. 50 feet versus 15-foot distances, compounding uncertainty. Open fire shall be best defined as a fire on the ground, such as a campfire. The allowable minimum distance from the fire to structure shall be 50 feet, and this shall be allowed only by the approval of the fire marshal or his designee. Okay. Well, let's continue. Earlier portions suggest open burning is prohibited. Here, the policy authorizes open fires if two conditions are met: 50 feet from structures and fire marshal approval. There is no codified procedure to apply for, obtain, or appeal approval. No timeline and no criteria. This grants unbridled discretion to officials to approve some residents and deny others. A resident cannot conform conduct to a secret standardless approval regime. The contradiction, prohibited versus constitutionally allowed, combined with licensing by sheer discretion, is constitutionally infirm. See Kolender, Kolender versus Lawson, 461 U.S. 352, 1983, unfettered discretion. Coates versus Cincinnati, Coates versus Cincinnati, 402 U.S. 611, 1971. Subjective standards are void. Let's continue. Controlled fire shall be best defined as a fire within a manufactured enclosure that is designed to contain seasoned firewood or charcoal, such as a barbecue or a Coleman type brand portable outdoor fireplace. The allowable maximum distance from a fireplace to a structure shall be 15 feet. Key terms are undefined here. What qualifies as a manufactured enclosure? A metal bowl from a hardware store, a masonry ring, a welded drum. What counts as seasoned firewood? By moisture percentage, by time, by species? The policy provides no metrics. The 15-foot distance also conflicts with the earlier 50-foot distance quoted from NFPA. And the policy gives no rule for resolving conflicts. These layers of ambiguity leave ordinary people to guess at compliance and empower officers to declare violations ad hoc. Exactly what Grained, and Colender prohibit. Okay, let's continue. A burning barrel, 55-gallon drum type, is not a controlled fire, all caps, and is prohibited, all caps, from use. Burning solid waste and yard waste is prohibited, all caps. Well, this clause collapses several undefined categories. Burning barrel, solid waste, and especially yard waste. The city provides no definition for yard waste. Does it mean branches, twigs, bark, mulch, or leaves? Worse, in practice, I, the defendant, was accused by both police and fire of burning miscellaneous vegetation. It's in multiple police reports. Miscellaneous vegetation. A phrase that appears nowhere in the city code or even this policy. The accusation itself demonstrates arbitrary enforcement. Ordinary logs and branches are relabeled miscellaneous vegetation to justify charges. They were, right? So that's, logs and branches that were in my fire pit were relabeled as miscellaneous vegetation to justify charges. Criminal liability cannot rest on undefined, elastic, or invented terms. See Papa Christou, P-A-P-A-C-H-R-I-S-T-O-U versus, see Papa Christou, 405 U.S. at 170, page 170, and Colender, K-O-L-E-N-D-E-R, 461 U.S. at page 358. In summary, open fires, controlled fires, small fires, and cooking fires are not specifically prohibited. There are certainly exceptions to this. And if the fire is on property not belonging to the person, i.e. parks, wooded areas, public land, is too close to a structure, is unsafe because of any other reason, or is offensive to others, we have the right to cease the burning. Wow. That's the most vague for voidness garbage I've ever read. Oh, let's continue. This paragraph encapsulates the policy's contradictions. It begins by stating fires are not specifically prohibited, and then immediately invents sweeping subjective exceptions. Phrases like unsafe because of any other reason and offensive to others lack objective content and allow officials to prohibit identical conduct for different people based on personal views. The Supreme Court has repeatedly invalidated such amorphous statements, A-M-O-R-P-H-O-U-S. I'm not sure how to spell it. I'm not sure how to pronounce that. I'm not an English major, but C. Coates versus Cincinnati, C-O-A-T-E-S versus Cincinnati, 402 U.S. 611, 1971. Annoying is void for vagueness. City of Chicago versus Morales, M-O-R-A-L-E-S, 527 U.S. 41, 1999. Anti-loitering ordinance is void for lack of minimal guidelines. When combined with the policy's earlier contradictions and undefined terms, this clause proves the scheme is standardless. It shall be the discretion of the officer to handle open burning complaints based upon all circumstances observed. This cumulating grant of unbounded discretion confirms the policy is not a rule of law, but an invitation to selective, subjective enforcement. There are no definitions, no factors, no thresholds, and no procedural safeguards. Two residents engaging in identical conduct could be treated oppositely depending on the officer. Such unchanneled discretion is the precise vice the vagueness doctrine seeks to prevent, because it chills lawful conduct and enables arbitrary punishment. See co-lender 461 U.S. at page 358, Papa Christou 405 U.S. at 170. Ultra vires nature of the policy. Even if the policy for controlled fires were clear and internally consistent, it would still be unenforceable because it is ultra vires. The Wayne Fire Department lacks legislative authority to create binding criminal law. Only the city council can enact ordinances through the codification process. At most, this policy is an internal guidance memo. Treating such a document as binding law exceeds the city's lawful powers and deprives citizens of the protections of notice, debate, and codification. Courts consistently strike down enforcement actions based on uncodified administrative policies because they deny due process. That's a violation of the Fourth Amendment. And then, of course, this policy invites arbitrary enforcement, and the city, I guess, thinks that they can just violate the Fourth Amendment, break into someone's home or curtilage to enforce it, which is a Fourth Amendment violation. But I digress. So in conclusion, this video has gotten pretty long. I probably could have got it cut down in half, but I apologize. The policy for controlled fires is an uncodified, internally contradictory, and standardless memorandum that cites phantom provisions and unadopted manuals while relying on undefined terms and officer discretion. It fails to provide citizens with constitutionally required fair notice of what conduct is prohibited, violating due process under the 14th Amendment. Two residents engaging in identical activity could be treated entirely differently depending on an officer's subjective labeling, creating arbitrary and unequal enforcement. The vagueness of this policy has already manifested into practice. I, the defendant, was personally accused of burning miscellaneous vegetation, a term that exists nowhere in the city or the policy itself, in the city code or the policy itself. Such arbitrary and undefined accusations prove vagueness not merely in theory, but in enforcement. Because the officer's entry and commands were based solely on this policy, this void policy, the interference charge is fruit of the poisonous tree and constitutionally invalid. The interference charge from May 9th. That's what got this whole entire party started. That's what got everything started. The interference charge is fruit of the poisonous tree and constitutionally invalid. Further, the policy's elastic and shifting terminology chills lawful conduct, leaving residents fearful of arbitrary punishment for ordinary use of their own property. Under well-established Supreme Court precedent, including Grayned, Grayned, Papachristou, Papachristou, co-lender, Kolender, Coates, Coates, Morales, Morales, and GIACCIO, I don't know, GIACCIO. This policy is void for vagueness and cannot serve as the basis for any lawful command. Accordingly, the interference charge that was connected to this policy from May 9th of 2025, where the city of Wayne broke into my property to enforce this garbage must be dismissed with prejudice. Respectfully submitted. So there's the vagueness of the open burn policy. Now we in the next video we are going to do the vagueness of the new soon-to-be ordinance 2025-02. So we're gonna be doing that next, and scary stuff, guys. Scary times that we live in. We're supposed to be the land of the free, home of the brave, but I don't see a lot of bravery, and I damn sure don't see a lot of freedom in this country. And yeah, 4 pages of garbage. Well, it was 1 page. The open burn policy is 1 page of garbage, but 4 pages to break it down for you. So, hope that's been informative, guys. I will see you in the next video. And as always, stay safe out there. Keep your head on a swivel. Don't become Charlie Kirk 2.0.